Good morning, everyone. Let's let everyone join in. Let's give it a minute or so here, and then we will get going. Thank you very much for joining us today. While everyone is joining us, I'm bringing up the agenda for today's meeting. Director Waters, before we get going, I have a brief little presentation just to explain the process of today's meeting. But before that, do you have any opening remarks?
I just want to welcome everybody. We are really pleased to see how many people registered for this. When we checked this morning, there was over 200 people registered. So we welcome your feedback and we're excited to hear what you have to say.
Thank you, Director Waters. With that, I'll just jump in briefly here. Again, this is a very short presentation just so that you all can be somewhat familiar with how we're going to be dealing with things today and for a few future meetings as well. So once again, welcome, and I appreciate your participation here today. This is a presentation that's going to be offered in order to address the non-rulemaking contracts and forms process here in Colorado. And so today's meeting is the first of what we are proposing as 3 dates to solicit comments from both industry professionals and the public regarding proposed changes to broker contracts and forms. Every year, as many of you know, the Division of Real Estate, at the direction of the Colorado Real Estate Commission, reviews and updates certain commission-approved contracts and forms. The division collects comments and suggestions from interested parties to guide those possible changes. I just would like to mention that that today's comments will be shared with the Real Estate Commission members. Again, this is the first of what we're envisioning as 3 meetings, and the division will communicate with interested parties once those meetings have officially been scheduled. And we'll have registration links, but those proposed dates at current, that they're tentative, are April 3rd and May 5th. So again, those are 2 Fridays that will be taking place in the future, and we'll expect that those will be very likely at 1 o'clock in the afternoon on those days as well, just like today. So the comments, or the contracts and forms that we are soliciting comments on today are found on the slide at present. I'm not going to read them all out right now, but the additional meetings that we will get scheduled will also have approximately the same number of forms, give or take 1 or 2 here, as well, so that we're doing these in somewhat equal batches of documents, so as to make it so that if your priority is the lead-based paint disclosure, that of course that you can attend this meeting. You don't have to attend the others, although of course you're more than welcome to and encouraged to as well. A couple important disclaimers. Every form that we are talking about today is a draft. They are not to be used in practice until such time as the commission approves them for use. All of these forms are still subject to change, and every document will have an effective date. Historically, this is often on January 1st of the first January 1st that takes place after approval by the commission. But all practitioners should always be taking particular care to ensure that they're using the correct form at all times in their practice. In order to participate today, many of you are familiar with the Zoom platform, but for those of you that are not, this meeting is being recorded and will be shared with the commissioners. In order to speak today, you can select the raise hand icon in the Zoom platform menu, and that's commonly found at the bottom of your screen. Division staff will identify you and be able to unmute you. And then once you are identified, please state 1, your name, 2, who you represent, and 3, your profession. Comments today will be limited to 2 minutes per person per document. We took this into a lot of consideration. Commonly, rules allow for 3 minutes per person. However, several individuals had reached out to the division and said, hey, 3 minutes is not enough to talk about 10 forms in some cases. So again, 2 minutes per person per document is sufficient there. And then after approximately a minute and 50 seconds or thereabouts, I may interrupt just to indicate that it's time for you to wrap up your comments. So in addition to oral comments, if you're less comfortable speaking, you may submit a written comment in the Q&A feature, again, located in the Zoom platform menu at the bottom of your screen. Similarly, like oral testimony, we would request that you include your name, who you represent, and your profession. One final comment here is if you do have written comments after this meeting, but prior to the non-rulemaking hearing, excuse me, you can also submit those on the division's homepage. It is on this slide that we have here, it is circled where you can submit written comments. And for those of you that would like to review the red lines that are featured in today's as well as future meetings, there is also a link there in the rectangle here where we've created a page where you can go and look at these documents and really hone in on what the changes are. And with that, I will say thank you very much for your attention today and pass it off. Thank you.
All right, thank you, David. I'll take over from here and we can jump right in. The first forms on the agenda are the lead-based paint disclosures and the lead-based paint disclosures for rentals. Because of the changes to the sales and the rentals forms are identical, I'm going to cover these two forms together. And if during the comment period, if you guys need us to look at one of the forms specifically, David's happy to pull up that form specifically. Before I get started on the changes to these forms, I just want to make note that you've probably noticed that on all of the forms, the header language has been updated, and the updates to these batch of forms, the header language just is identical to the changes that were made last year when the commission approved this new updated language during last year's form approval cycle. So the changes to the headers will be identical on all the forms we cover today, and I won't go through them all. All right, so sorry to jump out of order, but just going back to the lead-based paint disclosures, the first change that you'll see on this form is a change to the title, and that's just to make it more descriptive of the form's purpose. The next suggested change is to insert the date of the CBS that the disclosure is going to be attached to. This is simply for the sake of clarity and ease of reference if there, for example, has been more than one contract related to the property. And then moving down the heading, the disclosure of information on lead-based paint and/or lead-based paint hazards, that is suggested to be removed because it's really no longer necessary with the suggested expansion of the title form of the form. And then the remainder of the changes to this form were made to match the changes that the EPA has made to their sample lead-based paint disclosure form. And the purpose of the changes that the EPA made, their stated purpose was basically to provide greater clarity and specificity. So those changes that the EPA made to their sample forms that are mirrored here on this form, they include, let's go with there, the current version of the form asks the sellers to describe or to explain their knowledge regarding the lead-based paint hazards. Sorry, that's a tongue twister for me, so I apologize that I'll keep probably stumbling over lead-based paint hazards. So the suggestion is just to change having sellers explain their knowledge to changing that language to describe what is known about the lead-based paint or associated hazards present. And that change, it's really just intended to elicit more information from the seller and more detail, ask them to describe something so that buyers and renters may be better informed about the existing paint and paint hazards prior to buying or leasing the property. And then below that, there is a change to the indications for sellers, purchasers, and lessees and the other forms to initial the form rather than use a check mark. And that really, the intention of that is basically to increase clarity about who is supposed to be or who is responsible for that particular disclosure and acknowledgement parts of the form. And that again is been changed on the EPA sample form. And the updated forms, they also allow renters or buyers to indicate whether they received all records and reports relating to lead-based paint or lead-based paint hazards in the housing, such as an inspection or a risk assessment report. And previously, under the current version of the form, renters or buyers could only confirm if that they had received copies of all of the information. And now you'll see changes to the real estate licensee's acknowledgement section. And those include on, for example, the seller's form, the addition of the statement that seller's broker has informed seller of seller's obligations under 42 USC 485 2D and is aware of his or her responsibility to ensure compliance. There is also the addition of the statement, buyer's broker acknowledges that pursuant to federal law, if buyer's broker is paid by the seller or through a cooperative brokerage agreement with seller's broker, buyer's broker is responsible for ensuring seller's compliance with seller's obligation under federal law and has informed seller of seller's obligations under federal law. So this suggested change specifically is intended to comply with the requirements under federal law. Under that federal law, EPA and HUD have revised the definition of agent that's used in the law so that any party entering into a contractual relationship directly with the seller or lessor, or indirectly with a representative of the seller or lessor for the purpose of selling or leasing the target housing is an agent for the purposes of the rule. So as a result, listing agents, selling agents, and buyer's agents, if they are paid by the seller or through a cooperative brokerage agreement with the listing agent, they're all agents and are responsible for ensuring compliance under the rule. And since Section 1018 of the federal law refers only to agents having entered into a contract with the seller or lessor, buyer's agents paid entirely by the purchaser, they are not considered agents under this rule. So the changes to our form here, they're really just intended to clarify this standard that I just went over and to make sure that the brokers are complying with federal law. And with these suggested changes, the broker must initial the statements or enter NA if not applicable. This addition adds clarity to the section. Previously, there was just a blanket acknowledgement that applied to both brokers, that each broker has informed seller of seller's obligation. Now, based on this change, there would be two distinct places to initial in the section for more specificity. On the seller form, there's now one space for the seller's broker and one for the purchaser's broker to initial. And then on the lessor form, there is now one space for the lessor's agent and one for the lessee's agent to initial. So really, the importance of this change is like currently the division sees a number of transactions in which a buyer's broker just doesn't fill out the lead disclosure form because I guess they think it's solely the responsibility of the selling broker. And so these changes are really intended to clarify the responsibilities of buyers brokers and highlight to them that they may be obligated under federal law to complete the form. So we're really just trying to again, highlight their responsibilities for them and make sure that if they are obligated to fill out the form under federal law, they are in fact doing it so they're not opening themselves up to liability. And I think I've said this a number of times already, but the changes are the same to both the sales form and the rentals form. So that should cover it. If we want to open it up to comments or questions, I'll turn it back over to you, David.
Thank you, Ms. Phipps. If anyone does have any comments on these first batch of documents, I believe it's 4, please select that raise hand icon and we can identify you. Give it another 10 or so seconds, but I'm not seeing any hands at this time. Very good. Thank you for that explanation, Ms. Phipps. I'll pass it back to you and scroll down a little bit to the next batch.
Okay, well, I'm gonna go for 3 and 4 on the agenda, which is the lead paint obligations to seller and the lead paint obligations to the landlord.
Very good. All right.
All right, thank you. And again, I'll take these 2 forms together since the suggested changes to both of them are the same. And it's not reflected on the red lines that are before you today, but I was considering that it would be a good idea to revise the title of this form in the same manner that the title to the lead paint disclosure was suggested to be revised. So a potential revision to that could be seller's lead-based paint and lead-based paint hazard obligations as required by federal law. Again, just to be a little more detailed and specific about what this form pertains to. So the first suggested change is the addition of a line that identifies the property at issue at the top of the form. It's currently located at the end of the form. So just for clarity and ease of identification of the property at issue, the suggestion is to move that property information to the top of the form. And then you'll see change the use of the word shall to must, and that's simply just to comply with the principles of contract writing. The use of the word shall is discouraged, so the shalls are changed to must throughout the document. In paragraph 2, the proposed changes there, again, are just simply to have the language of our form mirror the language in the federal law. Paragraphs 3 and 4, those reflect what we previously discussed in relation to the lead-based paint disclosures just a second ago, just detailing what the buyer's broker's responsibilities are depending on how they are paid. In paragraph 5, again, this language is taken from federal law. The suggested new language is just a more detailed version that replaces the similar statement that currently is located towards the end of the form above the seller's acknowledgement. So it's just moving that language and expanding it a little bit. And then paragraph 6, just a non-substantive change to wording. Suggestion is just to make it read a little bit easier. And then finally, in the last part there, we added language no less than 3 years. Again, just for clarity, the previous language just said keep it for 3 years. That could possibly be interpreted as that the requirement is for 3 years exactly, and you should throw it away after 3 years. It's just to comply with the actual language in the law that says no less than 3 years. So that's all I have. We want to open it back up again.
Excellent, thank you. And we do have a hand. Eve, I've unmuted or asked you to unmute, and you should be able to address any questions or comments.
Sure. Can you hear me?
Yes.
All right. And I submitted this in writing too, so you could ignore that. I'm a little unclear. What I was looking at was the current forms don't appear to have any sort of buyer broker obligation. So I just want to make sure I'm understanding that the current form doesn't communicate that obligation, but it's always been an obligation under federal law, and we're just updating the form to reflect that.
I would say that's an accurate statement. I don't know if Director Waters, you have anything else to add, but that was our concern, is that buyers brokers, I think, were a lot of times disregarding this form because they weren't aware of their requirements under federal law, but under certain circumstances, they do have obligations for under federal law. So we just wanted to make sure that brokers were aware of those.
Good to know. Thank you so much. I appreciate it.
You're welcome. Thanks for your question.
Does anyone else have any questions or comments that they'd like to raise their hand for at this hour? Oh, yes. Tom, I've allowed you to talk.
Thank you. I just was going to try to recap exactly what the obligations were prior to and then after going under contract on this situation with this disclosure. Is that the right question I'm asking?
I'm not sure if I understand the question.
So if you scrolled back up to there, where it was talking about the obligations to seller,
Oh, is it number 5?
number
Is that-
5, thank you. Yeah.
Mhm.
So, so we would have to obviously when we're completing the listing, when we're having all our documents signed by the client prior, and then after going under contract on the property. I think I might have been just a little bit confused on that. Sorry.
And that language is straight out of the federal law, and it's my understanding it's just that all of the disclosures have to be completed before a particular buyer's offer is accepted, just to give them that opportunity to review the information. So if you say your seller had not completed all of the disclosures, and you know that, you have to make sure they get all of those disclosures completed before accepting that offer.
Okay.
If that makes sense.
It
If I'm
does.
explaining that properly.
Yeah. And so just in the event that if we don't have had this prior to the buyers accepting the offer, then is that I guess I'm just trying to clarify if agents forget to do that prior to an offer going under contract, if it's timestamped or anything like that.
I don't know, and I'm hesitant to try and provide a legal interpretation of the provision, honestly. So, I mean, I don't know. And
I don't think we can
Really?
also speak to how the EPA enforces that either.
yeah.
Okay.
But
Thank you.
again, sorry,
Yeah.
hopefully, I
Oh.
mean, the intent of this change is just to kind of alert brokers to all these additional requirements, just so they have the knowledge to go forth and ask questions to your employing broker or to your legal counsel or whatever, to figure out how to properly comply with your requirements under federal law.
Perfect. Thank you.
You're welcome.
Deborah, I've asked you to unmute. There you go.
Actually, this is Skip Howes with Howes Team Real Estate. I'm the broker.
Very good. Thank you, sir.
2 questions. One, obviously, the topic that was just discussed, just talked about, is we're going back to the old contract days of having the buyer sign along with or at the same time of the contract. So I'm assuming this will affect the dates in the chart for the buy-sell contract, where that will either be modified to say it's included, or that date will go away and can't be done after the contract is executed. Is that a fair understanding of the first item?
So it's my understanding, Melissa can correct me if I'm wrong, you've got to do the disclosure before the offer is accepted. So I don't know why it would then affect the contract deadlines themselves.
Because the contract currently, if I recall it, has a deadline for the lead-based paint disclosure to be made. I'm assuming that would then be withdrawn from that part of the buy-sell contract.
So we definitely would
Okay.
flag that, and we appreciate you flagging that for us of something to
Yeah.
change the CDS.
The
Yeah.
second question was, the EPA has determined that we are now agents. Do we have a definition from the feds as to what an agent is? Because a transaction broker is not an agent, and is the federal government now saying you as a transaction broker, as far as the feds are concerned, are an agent, but we don't know necessarily what their agency requirements are, fiduciary and or otherwise?
The agent, as it's used in the federal law, that really pertains to the method of payment as opposed to the obligations. And I'm trying to look over my notes here and see so I can read that to you.
So basically, while you're looking at it, it's the Fed's just looking at us like you're a travel agent, you're a insurance agent, you're a real estate agent. It's just a title. It's not necessarily defining the relationship other than payment.
Yes, I think that that's accurate. It's not the same kind of term of art that we use it with, where agent comes with specific obligations and responsibilities.
Yeah, with that in mind, I would suggest that the commission do a position statement on this. Otherwise, the world out there is going to be totally confused.
All right. Thanks for the suggestion.
Thank you. That's all I have.
Thank you.
Eric, I've asked you to unmute.
Hello.
All yours.
Hello.
So, similar to previous ones, I guess first question, did the federal law change? Is that why we're going back 15 years on these forms?
All I can tell you is my research into the federal law. The sample forms have changed, as far as kind of the more substantive changes that we made to this form, but I can't tell you at what point in time that change to like the definition of how they use agent was made. I don't have that answer off the top of my head. I think this form has not been, I can't see what the last time that this form was updated was.
2022.
Yeah, and
Twenty-
the reason two reasons I asked. One is how is a buyer's broker or buyer's agent have any ability to make sure a seller complies to this law, since they have no I mean, I guess if this was a for sale by owner, I could see that, but any other instance, the buyer's agent has no contact with that seller. So the way this is written, it's making them obligated to do something that they don't even have the ability to do. And then the second part is, because of the way our contracts have been now for several years, the buyer's not obligated under this, under the contract, under the lead-based paint, until they've received it, and then they have 10 days with which to object. So the problem we're going to have here, and we had this in the past, is sellers' agents don't provide the lead-based paint disclosure, and now a buyer is put at a disadvantage because they can't compete. So maybe another buyer's agent managed to get it beforehand, and you're in a competitive situation. So I'm trying to figure out why we're going back to that, where it becomes a disadvantage for a buyer at that point, when they still have, according to our contracts, the current contracts, the ability to object and to terminate that contract under lead-based paint. And so they're not obligated until such time that they receive it and they have the chance to. So making it applicable at the time of contract is, again, we've dealt with this, and it was not to an buyer. It caused harm for buyers, basically.
And I guess my response to that is I understand your concerns and the frustrations with that, but this is just merely replication of federal law. So it's not, any standards that we as the real estate commission are proposing. We're really just trying to make sure that brokers are in compliance with federal law. And if our contract needs to be updated in order to bring everything into compliance and in alignment, then we'll certainly take a look at this round of forms too, to make sure any necessary changes are made.
Right, but compliance with federal law says until the buyer has received this in writing and signed acceptance of it, or acknowledged, receipt of it, they're not bound to the contract. But the federal law that I've read, and I'm not an attorney, does not say that they have to receive it before they make an offer to buy. And that's why we went to the system we're on now, because they're still covered under the federal law with this document, even if they have an accepted contract in place. So again, having done this for 40 years almost now, I've been through all these iterations, and this is one that created a lot of issues for the public. So anyway, something that I would suggest you guys dig into deeper, because I mean we're basically going backwards as a state, and we, unless there's been some issues that I'm unaware of that we've run into, that you've run into as a commission on this, but we're kind of going backwards, and again, I think maybe dig deeper into interpretation of that. And then the second part with the buyer's agent, again, I didn't see that anywhere in the federal law where the buyer's agent was responsible to make sure the seller did their job. Is that something we're missing? I mean, is it possible for you guys to share the federal law with us so we know what it is that you're looking at?
So we don't have a problem sharing you the citation for the federal law. Our big concern with the contracts is making sure that they comply with the different regulations so that you are not being set up to be found out of compliance with these regulations. So even though it may be seeming like we're going backwards, it may have been a prior decision to basically kind of ignore that federal law and make things easier for you. Our concern is we don't want to set you up for failure with the EPA because it's a $10,000 fine. But we're definitely more than happy to dig into it deeper.
Yeah, that'd be great. I think the fine's up to 12 now, right? For instance. Thank you. I appreciate it.
Still hefty.
Thanks.
Thank you, Eric. Let's see, Tammy, I've asked you to unmute here.
Tammy Dietz, sorry, with Guide Real Estate Managing Broker. I want to second that comment there. We've had how many versions of this? We had contracts that said void, voidable. So now what happens if this doesn't come over? Where are we at with a contract? If I'm the buyer's agent, I want to send something over and I have no way to get it from the listing agent, how does that render my contract now when it goes over? And so that for me causes huge concerns. The only other thing I would add is, having done this a lot and seen a lot of deals come over, very rarely are listing agents sending over the pamphlet with the lead-based paint disclosure. When I say very rarely, I would say I see it come over about 10% of the time. Is there any way in both of these documents that we can have a hyperlink that actually includes the protect your family from lead in your house so that it's actually there? Because I'm just telling you straight up, this isn't happening. And it says the seller must provide it, but the seller has no way to provide it to the buyer because they don't have the buyer's contact information. They're relying on listing agents, and listing agents simply are not doing it.
So we can look into the hyperlink, Tim.
Thank you.
Thank you, Tammy. Anyone else that has any comments on these documents before we, oh, yep, it looks like Nicole does. Nicole, I've asked you to unmute.
Hello.
Gotcha.
My name is Nicole Stevenson. I am independently licensed and I primarily act as a transaction coordinator. So I just wanted to second what Tammy was saying. The vast majority of agents do seem to leave out that pamphlet. And I think the vast majority of agents don't even realize they're supposed to provide it. So I want to say on the line of this that the transaction file checklist that's up on the DORA website, I rely on that very heavily as a final audit for my clients. And that, along with the lead-based paint seller obligations form, are not mentioned on that checklist. And I think that might be useful for people to kind of flag in their mind, oh, I need to make sure I've at least provided that. I need to make sure I have the obligations form filled out, because it's not in there, the obligations form specifically. So that is my feedback.
Thank you, Nicole.
Linda, I've asked you to unmute. Linda, I see that you're unmuted, but we can't hear you.
I wanted to agree with everything that has been previously stated. The difficulty of attempting to get a seller to do something when I'm representing the buyer is, yeah, it's sort of out of our hands. So I hope that this helps to clarify for our customers that, well, we'll see where this goes, I suppose. Thank you.
Thank you, Linda. Anyone else before we move on? Seeing none? That brings us to the brokerage disclosure to tenant. Oh, Melissa, it looks like you might be speaking, but we can't hear you. Bear with us for a technical moment. There we go. Gotcha.
Can you hear me?
Yes.
Okay, great. I was wondering, I was thanking people and then Marcia was thanking them as well. I was like, oh, can you guys not hear me? That explains it. Okay, so I have the brokerage disclosure to tenant, brokerage disclosure to buyer, and brokerage disclosure to landlord taken together as a group, since again, they have the same changes made to all three of the forms. So there's not a lot of changes, no changes to the beginning of the form, not down to the second page there, where there's the removal of the paragraph that contains the blanket waiver of confidentiality. And that's the same paragraph that's came up with the listing contracts in last year's cycle. And that paragraph or that waiver has been removed because it doesn't meet the standards of informed consent that's required by license law prior to the sharing of confidential information. And then below that, there is an expanded statement regarding the disclosure of settlement service costs. And this new language here that's suggested that simply conforms to the changes to similar provisions that were approved by the commission last year. So the change is just for the sake of consistency with the other forms that have similar provisions in them regarding settlement service costs. And then the statement, this is not a contract, that's just been moved down to just above the tenant acknowledgement in that particular form. And there is also the suggested addition of a statement which refers the tenant or buyer in this particular form to the definitions of working relationship disclosure document if they need any further information to understand the different brokerage relationships. And then under that, the next suggestion is the suggested addition of the employing broker's name, which just helps to fully inform the consumer of the full scope of the brokers potentially involved in the transaction. An employing broker could be providing supervision. This just informs the consumer of who that additional broker that may be involved is. And then there's just the addition of the word signature after broker. Again, that's just for clarity. I don't think the signature is added after, in this case, the buyer signature line, but we can change them all to make them consistent as well. So that's all I have for those for 5, 7, and 8 on the agenda.
Therefore, if anyone has any comments or suggestions, Tammy, looks like you do. Ask you to unmute.
I just have an easy request. When you put these into CTME, can you have two different versions? One that has the commission agreement with the buyer and one that does not. We have scenarios where people are representing people with customers. There'll be no compensation. And so that's really confusing the buyers to have that in there when it's not always needed. So if there can be two versions, one with the extra page and one without, that would be so helpful.
Okay, thank you.
And Eric,
Yes, the question is, what's that second page take out? Because I didn't see it with the documents about compensation.
Yeah, let me pull this up here.
Or was it just not because there were no changes?
No. Tenant. Yeah, the brokerage disclosure to tenant doesn't have that another page for
Oh, you know,
compensation.
I get right. Yeah, it was a broker disclosure to buyer, the BDB 24. I'm thinking because I did you already cover that one? Did I miss some there?
She did them as a group
Yeah.
since the changes are consistent across
Okay,
the
so
four.
yeah, okay, because the BDB 24 had that second page added a year or two ago that
Mhm.
discussed compensation.
Yeah, I just did them as a group, sorry.
Is that no longer part of the BDB 24? That's right.
We didn't remove the compensation
So
language.
is that gone from the BDB 24 then, I guess?
No, we didn't remove
No.
the compensation language from
Okay.
that form.
So that is still,
Go ahead.
excellent. I just want to make sure it was still there, you know whether it was or we were going with a separate form. So, all right, thank you.
anyone else? April.
Hi, can you hear me?
Yes.
Okay. This is April. I'm an independent broker owner, employing broker, and I use the disclosure to buyer regarding this form, and I use page 3. And so to kind of clarify what Eric was asking, I'm just curious, has the third page been eliminated from the brokerage disclosure to buyer? That's my question.
No, it wasn't an intentional removal. I'm trying to see if the version that we have up here doesn't have that on there. I'm trying to flip around to numerous screens here.
It could be just a matter of repagination from on this red line version that made it so that that acknowledgement was on the third page, I believe. Is that what you're referring to, April?
Yes, that's exactly what I'm referring to, is specific to the brokerage disclosure to buyer, the third page. I find that very, very helpful. I use it all the time, and it combination of the definition of relationships along with this is really great to use if I have a customer in front of me that wants to see property and have me write an offer that we haven't gone into a buyer's agency. They know up front, I've disclosed, I've let the public know that I'm hoping to earn something from this, and we're going to work together, or, just it's up there and it's up front is what I'm trying to say. So I heard yesterday in a contracts class from a real estate school that said that page 3 is going away. So I just need to have full confirmation if it's staying or if it's going, please.
So we were not given direction from the commission to delete the compensation language. So it's not going away. It just looks like it was something that we omitted when we uploaded these forms to the website for this meeting. So there's not going to be any changes to the compensation language.
Thank you.
Thank you, April. Any other comments? Again, please select that raise hand icon if so. Not seeing any at this time, though.
Okay, so then we can move on to, or I guess back to, I'm sorry, number 6 on the agenda is the brokerage disclosure to seller, the for sale by owner. Sorry to get you out of order, David.
Not a problem. Here we are.
All right, thank you. On this form, again, no changes in the beginning. Just see, really, if you scroll down a non-substantive change, I don't know if it's just a formatting issue, but the version that I was working on when I made these red lines kind of showed that check one box only had like a bullet point next to it. And so that was a lot of like deleting and moving around just to try and eliminate that check, the little bullet point that I saw next to it. That was purely formatting issue, so nothing really to see there. Sorry for that distraction. And then the next suggestion, the suggested change down there is again that removal of the blanket confidentiality waiver, just to make sure that we're not out of compliance with license law that requires the informed consent. Again, that expanded language for the disclosure of settlement service costs. That's just making it consistent with the changes we made in last year's form review cycle. And then I guess if we scroll down, those are really the other non-substantive changes that were made on the other forms that we just covered as well. So that's all I have.
Any comments from the public? Not seeing any hands on this document.
All right, and then so sorry, we'll jump back down to number 9, which is the brokerage duties disclosure to seller, the REO and non-CREC listings. This in the beginning here. Oh, sorry.
Bear with me. I think I might have made an error there, so I'm gonna get a different document up rather than this big combined version. And here we are.
Oh, all right, thank you. All right, here, what the suggestion is just to flip paragraph 2 and paragraph 1. It just seemed to make sense to have the pertinent details of the transaction coming first, and then having what was previously paragraph 1 now is paragraph 2. And so the changes that you see on paragraph 2 there, it's just taking out as defined below because that's no longer relevant because paragraph 2 is now paragraph 1. And then again, going down, it's the same thing that we've talked about already. That's just formatting stuff. If you go down below, it's just the again, the removal of that blanket waiver of confidentiality. And then down below that, again, the expanded statement regarding the settlement services costs there. And then that's adding in the language of it's just the disclosure of broker's working relationship, and we can seller can refer to the definition of working relationship disclosure if they need additional information. All that, and I think the changes below to the signature lines are the same as what we've already discussed in the previous documents. So that's all I've got.
Any comments from our audience? Yes, Doug, I've asked you to unmute.
Good afternoon. Thanks for having this. I'm Doug Emmerich, broker owner at Colorado Relocation Professionals. Although I'm not a fan of the removal of the consent to provide disclosure, I noticed that language was not deleted from the brokerage duties addendum to the property management agreement, form BDA 55-6-23. And it should be 4.3 of that form should also have, I guess if we're going to be consistent, have that language removed from that document as well.
Okay, thank you for pointing that out.
That's all I've got.
All right, thanks for pointing that out. We'll make sure we get to that one and take it out of there
You
as
bet.
well.
Yes, Anna.
Hi, I'm Anna Kibble. I'm the managing broker with Fathom, Colorado. And I have a question about the addition of the employing broker's name to these forms. Is
Mhm.
that something that we're going to see suggested in addition on the other agency documentation, like the exclusive rights, adding the employing broker?
I think the answer to that question is really up to the commission if they want to see that added to the other forms or not. This is just a suggestion for them, and I think we'll leave that decision up to them whether they like it, and if so, on what forms that it's necessary to be on.
Anna, just to give you some background from our perspective, it's helpful if the consumer knows who the employing broker is, so that if they're having a hard time contacting their designated broker, um, they know who to contact. We would rather them contact you and resolve their issue before they come to us.
Thank you for that, Marcia. I was just going to ask for some background on the addition of that line.
Yeah.
Great, thank you.
Yeah. Doug, it looks like you might have re-raised your hand. I'm not sure if that was an error or not. But
I just fat fingered the mic button, so
no worries.
no other comment. Thank you.
Not a problem at all. Tammy, then.
Marcia, I had already mentioned this to you earlier, but sometimes the employing brokers are not doing anything for the company other than being there in namesake. And I've ran into this twice in the last month. So they direct you to a managing broker. So I'm wondering if employing broker is always the right name to have on there, because I found twice that it did not help me get the information I needed.
So we can definitely take that into consideration as well, and maybe also identify the possibility of a managing broker.
Thanks for that, Tammy. Any other comments at this time? Does not appear so.
All right, so going on to number 10, which is the exchange addendum to contract to buy and sell real estate.
Getting it open. Here we are.
All right, so that first change there, just the suggested addition of section 1031, just to make the purpose of the form more clear to the consumer. If someone is like, hey, what's this about? It just gives more information to direct someone to exactly what type of exchange this form is in reference to. And then below that, there's just some formatting changes, trying to make those checkboxes actually more functional. And then for paragraph 4, the substance of that paragraph is the same. It's just merely reworded with the hopes of making it a little more clear and for the ease of understanding, making it a little more understandable to the consumer. And then under that, the only other thing is the word exchange was spelled incorrectly, so just fixing that. And that's all the changes I have.
Any comments on this document? Seeing none, Melissa, I'll pass it back.
All right, thank you. The last one on our agenda is the definitions of working relationships form. All right, so that first suggested change, it just moves that freestanding statement that was at the top regarding the different types of brokerage relationships. It just moves that into the body of the document. And then the change in the seller's agent paragraph, there's the addition of that line. The buyer may either be unrepresented or represented by another agent. This is just intended to clarify for the consumer that a broker cannot represent both the seller and a buyer as an agent. And then the line that is suggested to be deleted, that's just been moved to a later part of the document. You'll see when we get there in just a second that all of the duties of an agent and transaction broker, we've kind of listed those out explicitly in bullet point format. So that's hasn't changed substantively. That line is just located later on in the document now. The same changes made to the buyer's agent paragraph. Same thing there for the transaction broker paragraph. The changes again were intended really for the sake of clarity, rather than having, all of the obligations kind of listed out in the paragraph and a kind of rather lengthy paragraph. We've just, that suggested new format just takes those out of the paragraph form and puts them into bullet point form later on in the document. And then that suggested change, the addition of that first line, it just makes a clear upfront statement that a transaction broker is not an agent for either party and does not advocate for the interests of either party. Just kind of putting that right out there upfront, so it's easier rather than having the consumer kind of read through that whole paragraph and sift through the different responsibilities and obligations to get to that point. And then the suggested last line makes it clear that the transaction brokerage is the default relationship and reinforces what's already stated in the above paragraphs, that an agency relationship only exists if there has been a written agreement completed. So going down to the bottom of the page there, that duties and obligations section, that's what I referenced about having all of the different duties and obligations listed out in bullet points rather than having them kind of buried within the paragraphs. And really, the intent is just to make it easier for consumers to access that information, to digest that information. And it also, I think, makes it easier if you're a broker going through this document with your client, just going through them in bullet points, I think makes it easier to explain, makes it easier for everybody to understand. And it's also a point of reference to go back to if, you need to point your client to something in particular. I think it just makes it easier than, as I said, sorting through those paragraphs. And then below the duties and obligations that are all laid out, there's just that brief section of what the duties and obligations do not include. And then under that, there is the suggested addition of a paragraph that's titled General Information. And this is intended to provide the consumer with a more complete picture of the brokerage relationship, including the structure within which their broker is working, and gives the consumer information that there may be other brokers involved in the transaction, namely the employing broker or supervising broker. And that additional information just equips the consumer with the knowledge of the statutory constraints that all those different brokers, that a designated broker, an employing broker, supervising broker, are working within. So it's just to provide the consumer with more information, as I said, about kind of a more accurate picture of what the brokerage relationship looks like and who else may be involved in the transaction. And below that, we just flip the broker's acknowledgement to come first. Seems to make sense that since the broker is providing the document. Again, there's addition of the line to put the employing broker's name there, and we can look into expanding that to, as Marcia said, maybe adding supervising broker. Again, just to make sure that the consumer is fully informed about everybody that could potentially be involved in the transaction. So that's all I have for that.
Thank you. While anyone else is contemplating comments, Eve, I've asked you to unmute.
Great, thank you. Again, Eve Evans, Integrity Real Estate. I'm a real estate agent. I guess I'm curious why these additions are being made to the definitions as opposed to disclosure to broker's disclosure to buyer, broker's disclosure to seller, versus the definitions. Because I think it's great, but I think it should be on the other two documents.
Do you see it being on the other two documents instead of this one or in addition to this one?
I guess I don't mind it being on this one, but I think it definitely needs to be on the other two.
Okay.
And right? Like everybody gets trained somewhat differently and it's been a while. I use this document when I am meeting people for the first time so they understand the context of the meeting. I don't move forward and work with anybody with this document. It's going to be a broker disclosure to buyer, you know, if I'm showing my listing to an unrepresented person. So I just think it's more important on those documents.
Okay. And that's a great point. Thank you.
Thank you.
Anyone else have any comments at this time? Not seeing it. Oh, beat me to it. Anna, right when I started saying it.
Hi. Yes, Anna Kibble again, managing broker with Fathom Realty. Just a question on the intended use of this document, because spelling out the duties and obligations is quite redundant for the agency agreements. Oftentimes we see agents using both the definitions of working relationships and the agency agreements together. Do you think that's redundant and unnecessary, or would that be a best practice to continue moving forward, even with this information?
I think it depends on the timing. I mean, this document was really designed to help educate consumers if the brokerage firm doesn't offer all of the different brokerage relationships that are available. Although I don't necessarily think that it's bad to explain all of the different working relationships to a consumer so that they understand it. But if your first contact with a consumer is a listing agreement and they sign or a listing appointment and they sign the listing agreement, then you wouldn't have to do the brokerage disclosure document. If you offer all of the brokerage relationships, you wouldn't have to do the definitions of working relationships. So I think it's going to just depend on the circumstances.
Okay. Is there any conversation of including the definition of all of the working relationships into the listing agreements? Because I think that's one of the arguments for using this form in addition to the listing agreements is my exclusive right to sell doesn't talk about the way we work with buyers.
We can definitely take that into consideration. The listing contracts aren't up this year, but we
Sure.
can add that suggestions to the global list.
Okay, thank you.
Thank you, Anna. And Doug.
Yeah, thank you. So definitions of working relationships, my understanding is that it is not a disclosure. It is an information piece to describe what the relationships are in the state of Colorado. But on some of the earlier revisions that we looked at, I think on two of them, there was a reference saying if you want more information about these relationships, refer to the definitions of working relationship disclosure. It should probably be the definitions of working relationships form, since this is not actually meets the status, if you will, of being a disclosure document. Am I correct in my understanding of that?
I think that's a great point. I don't know, Director Waters, do you see?
No, I think you're correct.
Yeah, we'll make
Okay.
that change. Thank you.
Thank you.
Any other comments at this time? I am not seeing any. So that is all the 11 documents that we have for you all today. Again, we are expecting that our next meeting will be April 3rd at 1 p.m. That is a Friday. That meeting will also be conducted via webinar. In the same vein that we communicated out about this meeting, which you've all found, we will send a notice out to all interested parties, which includes consumers, and other non-licensee industry professionals and the like, as well as real estate brokers, appraisers, and mortgage loan originators. So we will do that. And then finally, I would reiterate that there is a banner on the Division of Real Estate's homepage at this time, and that will remain there once we have a registration link for our next meeting and a more robust identification of which documents we will be covering at that meeting, both a calendar invite as well as that information on that banner will be updated so you all can see what the next couple forms that we're going to address are. And with that, if Director Waters or Ms. Phipps doesn't have any other closing remarks at this time, I would like to personally thank you all for attending today and bringing forth quite a few very, very good comments and questions and suggestions. So thank you very much.
Yes, thank you all for your participation. We really appreciate it.
Thank you and have a good weekend.
Thank you.
All right.